SJC-10079, Commonwealth versus Dennis M. Bateman.
Okay, Attorney Codignoni.
Amy Codignone.
Great.
Good morning. May it please the court, Amy Codignone on behalf of Dennis Bateman. There are 4 issues that I'd like to address today. The first is why the racially biased foreperson on an interracial murder requires a new trial. The second is the withheld evidence and the prejudice that flowed from it. The third is that there are 4 avenues to suppression, and I'd like to specifically address the agency question. And the fourth is the error in the DGM Batista instruction. But before I get started and before I begin, I would implore in this case that this court take its 33E review obligations seriously. I am asking that this case be looked at
Opposed to our other times?
in the cumulative. This is a case where the Commonwealth, in their brief, has conceded 5 errors. They have conceded that there are 5 errors, and there are many more errors that are raised. This is a case where Mr. Bateman has maintained from the outset that he is actually innocent. And
Why don't we start there, okay? Because that's important for 33 review, right?
Sure.
Right, so we have his DNA matching on the belt, right?
We do.
We have 1 in 250,000 people on the fingernails, right?
We do.
We have within minutes he's present during the time the murder takes place, right?
I disagree with that, Your Honor.
Really, go ahead, do that.
I disagree with
you're throwing around a lot here. And so let's start with actual innocence.
I would suggest to the court that there is a gentleman by the name of David Williams, who this court is referencing. And Mr. Williams says that he saw a van that he thought...
He's there, right? His DNA is on the belt.
He is, but he admits that he was there. So I would suggest to the court...
His DNA is on the belt and the fingernails, right? And the timing, what time does he place himself there?
Earlier in the day, around 3:30 to 4
And
4
how many
o'clock.
people place the van there at 6:30?
There is one witness who drives by and indicates that he sees the van there at 6:30. There is another witness that's an issue pending before the motion for new trial who was there at 6:30 who says that she saw a red truck. The other witnesses see the van there earlier in the day. And it's not, this is one of the issues in this case. It is not the same van. The Commonwealth has presented in its brief that it is in fact the same van. But if you go back and you look at each witness's testimony describing the van that they saw.
And we're going to do that because, because a lot of your briefing is based on very sketchy fact stuff. So we're going to do that very carefully because
Absolutely.
You've raised like 25 issues and it's very hard to dig into each one of them because each time I do that, the facts start evaporating here. But go ahead.
Well, so I would suggest to the court that the facts here support the claims, and I'm happy to as long as I can, talk about those.
Go ahead.
But this is a case where the Commonwealth has conceded 5 errors, and ultimately, from start to finish here, this case was not tried fairly.
I thought we were talking about actual innocence. You were saying there's evidence of that there's no evidence.
What I'm saying is that he has maintained that he is actually innocent, and he behaved in a way that was consistent with that at the outset of this case. And when this court evaluates the case, this court needs to evaluate the claims in the cumulative. That is what I'm asking the court to do. That this court not look at this piece by piece, but at the end of the day, whether this case was fair requires a cumulative review of the case. And with that, if I could, I'd like to...
As far as I can tell, the issues of errors, and there are errors here, they relate to the jailhouse snitch. Yes. And I'm going to mispronounce his name. It begins with a B.
Bogas.
Right. So there are errors there with the detective and him. There's also a devastating cross-examination of this witness, isn't there? Basically showing he says, I'd give up my mother for a break, right?
Sure, he does. And I would suggest to the court that his cross-examination was done well. But with a witness as important as him, the cross-examination here was focused on things like that, theoretical. I would turn in my own mother, if it were true. I would turn in my own mother. And counsel attempted to show...
I'm a great liar. I'll turn in my own mother. I've done all these things, right?
Counsel tried to show why he would lie in this case. And what he was trying to show was this is what he does, that he's a rat, that he turns on people. But he had one instance with which to show that, the 1993 cooperation. He didn't show it with the 1980 cooperation because that was withheld, and he failed to use the jail calls that showed that he was cooperating as the lead up to his interrogation of Mr. Bateman. So it was different in kind than the information before the jury, but the withheld 1980 cooperation matters because Mr. Bogaz lied to the jury. He said, I have only ever informed one time on Mr. Thurston, one time. And to be able to catch a witness like Mr. Bogaz in a lie would be incredibly powerful cross-examination because it was unlike anything else that he had. He had no information to suggest that this witness was lying. He was trying to convince the jury that he would lie. He would turn in his own mother. You can't tell if he's a good liar, and that's a great cross-examination. But to be able to show that he lied to the jury, there is nothing that powerful. Imagine what a great criminal defense attorney, or even a good one, could do with an actual lie. He's willing to lie to you because he did. We can prove it. And so with that withheld information, they can prove that he lied. And I would point this court to Cowles of 2015 from this court, where the court indicated with a witness like this, even that individual was impeached all day long. He had, I think, a 19-page record. And with a witness as crucial as Bogaz, it can't be cumulative because at some point the jury is going to disbelieve them. And this could have been the piece, the lie could have been the piece to prove that he was lying not just about his prior cooperation, but he was lying about what he was saying Mr. Bateman did.
How about all the other non-jailhouse witnesses in which your client essentially is covering up what he's doing? It's not just with the, you know, we've got the testimony of the two jailhouse people saying, hey, I want you to provide me with an alibi. But we have all this other stuff, including with the man's wife, the victim's wife, excuse me, the victim's husband, where he's going to the victim's husband and sort of bringing up all kinds of information. It's not, I mean, I just don't know how important these two jailhouse witnesses are, and they're clearly bad witnesses.
So I would dispute that these other witnesses are bad witnesses. The fact that Mr. Bateman is trying to establish an alibi when the police are asking him for one, I think that could be considered innocuous evidence. He's walking around with a notebook trying to ask people, was I with you from 4 to 6 p.m., which, by the way, wasn't even when the murder took place.
Bringing up the belt himself. No one knows the belt is
He's trying to tell the police what happened that day, Your Honor. So bringing up what happened that day would be...
They're not asking about the belt.
Well, if you believe the police recitation of the evidence, but I would remind you that we don't have a recording of it. So their recitation of when things happened in sequence, we don't have a recording of it, which is why their recitation of it should have been evaluated with great caution and care.
Didn't he also go to the liquor store and ask for some testimony there, and then the videotape showed that what he was asking relative to a time wasn't the actual time that he was in there?
But he went in to ask for proof that he had been there that day. He was trying to establish his own alibi because the police were asking him for it.
I know, but the point is the timing. Didn't he go in and say, I was there at this particular time?
Right. He thought that he was there, I think, at 4 or 5 p.m., and the video showed that he was there at 3:30. But the point is, he wasn't trying to cajole an alibi. He was trying to verify where he was for the police because the police had asked for it. But I suppose what I would like to say, because there are many legal issues in this case that these violations of his constitutional rights still matter. And getting back to the issue with the biased juror, that is an issue where the person who was ultimately selected as the foreperson of the jury told the judge that he believed that by virtue of Mr. Bateman's skin color, he believed that he was more likely to commit crime.
There was no challenge for cause, am I right?
There was no challenge for cause.
And there were peremptories left.
And there were peremptories left. And I have raised that.
So what can you do with that?
Well, I have raised that as an ineffective assistance of counsel because I think allowing a biased juror to get onto a jury is per se ineffective, and I think that is dictated by the Weaver decision.
Didn't he say, so it's been a while since I read the transcript, but didn't he say something like, that has nothing to do with this case?
It does.
You have to decide this case based on this individual?
The question that was asked was, having the information that black people are statistically more likely to commit crimes, would that affect your ability to decide the facts of this case? And he said no, because that has nothing to do with this case. But this court knows that has everything to do with this case because this case was tried to that juror's prejudice. This is a case where Mr. Bateman was alleged to have stolen a $5 bottle of liquor and then conned somebody out of gas and then gone to murder someone who is his friend and her unborn child so that he could get $300 to go on a crack binge. That was the Commonwealth's theory of the case. The theory of the case was that he was committing crimes left and right. So whether or not a black person was committing crimes was the juror's task. It had everything to do with the case, and the court didn't probe further. And that's why this court can't defer to the finding of indifference. There's one question to the juror about whether or not it would impact his ability to be fair and impartial, and the answer is non-responsive. This court cannot be assured that he didn't employ that bias, his bias that was...
I thought, I mean, again, from the details of what he said, and I'm not condoning what he said, but he said that statistics show there are more crimes in these neighborhoods, right? That's what he said.
He said that he believed...
And then when asked about the individual case, he goes, no, I'm doing that on an individualized basis. So I'm not saying it's good, but it's different from what you just represented.
I don't think that he indicated that he would do this analysis or this review on an individualized basis.
Why don't you go through the question he said, why don't you do exactly what was said as opposed to characterizing it?
Absolutely. If I could just have one moment.
Mm-hmm.
The court asked, are you able to keep an open mind in deciding this case solely on the facts introduced at this trial? The juror answered yes. Are you sure of that? Yes. Could you give both sides a fair trial? Yes. Would the fact that the defendant is African American and the alleged victim is white affect your ability to decide this case fairly and impartially? No, it would not. Do you believe that African American males are more likely to commit crimes than individuals from other racial or ethnic backgrounds? Yes, I believe they probably are. Why is that? By statistics, from what I've read, not just more likely to commit crimes, more likely to be victims. There apparently is more crime in the African American community, in my opinion. Having that information, would that affect your ability in deciding the facts of this case? No, because it doesn't have anything to do with this specific case. And then the court moved on. And I would suggest to the court that it has everything to do with this case.
What's the follow-up question at that point?
The follow-up question is...
What question should have been asked at that point, after he says, no, it has nothing to do with this, I'm going to decide this based on the evidence?
Well, I don't know what the exact question should have been, Your Honor, but there should have been more probing, because the court was aware that this case was going to be tried on...
Well, but as I'm listening to what he said, as it's set out specifically with what this juror said, he's referring to something he's read about statistics in cities and black people being more likely to be victims.
He says that
also
more likely.
He's recognizing that he's read something about more crime.
He says that they're more likely to commit crimes and more likely to be victims.
He said both.
He said both. But this is a case where he was being asked whether or not Mr. Bateman, a black man, committed an interracial murder. So his belief that by virtue of Mr. Bateman's skin color, that he was more likely to commit crimes, and those were his words, more likely to commit crimes.
Men are more likely to commit crimes too.
I understand that.
So 99% of violent crime is by males. So we could factor that in and consider that a bias?
Well, so what I would suggest to this court is there should have been more probing here. In my opinion, a person who holds a racial bias should not be able to sit in judgment of that person. If they are biased against their race, they shouldn't be able to sit in judgment of that person.
But if you know the general, let's just assume hypothetically, and I don't know if this is true or not, that the facts that he was citing are accurate. I have no idea. I've not read anything that he's suggesting. But what if somebody knew that men are more likely to commit violence? Would that be a bias?
There should be some probing as to whether or not he's going to apply that to Mr. Bateman. The fact that...
And so what, like Justice Kafka asked, what would you want them to ask further? He's already said it's not this case.
Well, I think there should be some...
thing.
There should be some instruction to the juror that it has nothing to do with Mr. Bateman, and given that it has nothing to do with Mr. Bateman, is he able to set that aside? If he's not able to set it aside, then he is going to employ that bias in the jury room.
But didn't he say he could set it aside without being asked? He just said it has nothing to do with this case.
He said it has nothing to do with this case.
So what else would the court asked to elicit the same answer?
Well, because the court knew that it had to do with this case, that it was a black man accused of committing crime, so it has everything to do with the case.
I'm trying to square your argument with what we said in Williams, because thank you, Justice Kafka. You know, jurors come to serve as who they are, with all of their experiences, and we talked about in Williams how even if there is some expression of some concern with the system or some other things, we all have our own implicit, if not explicit, biases. And so when you have a situation like this, where do we draw the line and say, you know, it's not necessarily an attempt by the trial judge to rehabilitate this potential juror. He asked the questions, he expressed his views, and then said it has nothing to do with this case, and I can serve fairly and impartially. Is the judge just supposed to, the judge who's also judging the credibility of the answer makes a determination that they're indifferent? How far do we go?
So I think that the record needs to support the finding of indifference, and here there's just one question, and then there's an answer that I would suggest to the court is non-responsive, because there's no probing about how this is exactly the case. That is this
Okay,
juror...
I'm sorry. So, but given all of that,
Yes.
there was no challenge and there
Understood.
was no
And if I could
peremptory
just
use.
move on, I don't want to spend all of my time on this one issue. There are a number of issues that I was hoping to address this morning. The other thing, if I could just back up, there is a case that was where the United States Supreme Court advocated for structural error in a denial of cert in April of 2022, Christopher Love versus Texas, on an almost identical factual issue, and I have advocated for structural error. I would just ask that the court look at that decision. But with regard to the withheld evidence,
It's a denial of cert?
it was a denial of cert on procedural grounds and a number of issues, but three of the justices dissented and argued that we should take this case and we should make clear that structural error applies. There are a number of categories of withheld evidence, and I realize that I'm running out of time. We have touched upon Mr. Bogaz's prior cooperation and his perjury attendant to that. With regard to Debrick Sweeney, there was a number of different categories of information that was withheld. Mr. Sweeney was largely unimpeached at the end of his cross-examination. He testified that the police had approached him and he had to do what was right. His only impeachment was effectively with drug crimes. But there was a threat in coordination with the police department and the probation department to get him to court. And that threat, I would suggest to the court, of a pending probation surrender, particularly where the Commonwealth knew that he was facing a 10-year sentence that the judge had all but promised him. That employment of a probation surrender to get him before the court to sort of force his cooperation was exculpatory and should have been turned over. That could have been viable impeachment evidence for Mr. Sweeney, for which there was none.
What does Mr. Sweeney add to this that others don't add? Why is his, what is specific to Sweeney?
So he corroborates, I would suggest to the court, he corroborates Mr. Bogaz's testimony in a way that the other witnesses, arguably, Mr. Bateman is going around trying to establish his alibi. But this witness suggests that he is doing it in a way to sort of force, just as sort of the court was...
But I'm confused, though. So because you're drawing a distinction between what he did with the non-jailhouse people and what he did with the jailhouse people. Mm-hmm. And I understand with Bogaz basically describes him confessing to everything.
Yes.
Does Sweeney describe that, or is he just another example where he's trying to place himself somewhere during the time frame of the murder?
Sweeney is a person to whom Sweeney says he tried to force an alibi out of him by threatening him. Mm-hmm. And that's where that comes from. The other witnesses don't describe that type of interaction, that he's just trying to establish where he was. This is a sort of, I know I wasn't there at that time, but I'm going to tell on you if you don't say exactly what I want you to say.
Can we just, go ahead, finish your answer, I'm
No,
sorry.
and that's why I think that he corroborates Mr. Bogaz, but he also provides his own inculpatory spin on things.
Before we run out of time, could you just address Giambattista for a moment?
Yes.
Because there's nothing, whether it's the expert testimony instruction that suggested, or Giambattista, or many other instructions, even the homicide instructions, where there's any sense that you have to do it verbatim. And so Judge Agostini hits both points of Giambattista. So where's the error there?
So I would actually suggest that he doesn't hit the point of that is a core concern of Giambattista, that they have to evaluate the precise contents of the statement. The use great care and caution and care was tied to voluntariness only. It said specifically, great caution and care when trying to assess the totality of the circumstances. But a core concern of DG and Batista was that police are not tape recorders, that the police recitation of a statement depends on their memory, and the jury was not asked to evaluate the precise contents of the statement. And the Commonwealth seized on that in closing argument by, and I don't want to go over, but essentially by 7 times calling the jury's attention to things that the police said that Bateman omitted in his statements, and also by mocking the idea that the recitation was not accurate.
Okay, thank you.
Any other questions?
No, thank you.
Okay,
If
thank
the
you
court
so
has no
much.
further questions, I would rest on my brief. Thank you.
Okay, Attorney Townsend.
Thank you. May it please the court, Thomas Townsend for the Commonwealth. The DG and Batista instruction, as was noted, there is no specific mandated verbiage that shall be given, but the language that Judge Agostini did use is found directly in DG and Batista, and I quote, "Jurors should use great caution when trying to assess the totality of the circumstances when they have before them a highly selective sliver of those circumstances."
Yeah, but the appellant's argument, though, is that one of the reasons for a number of years we said, you know, record these, and finally the court said, oh, you're not doing it. If you don't do it, then you have to give this instruction. And one of the motivating reasons for wanting these taped is because we're concerned that the recitation of what happened might not be accurate. And it protects people being interrogated, and it protects the police, too. But that leg of Gian Battista seems to be missing.
Well, there's the 2 required components of DG and Batista. One, that this court prefers that these be recorded, and secondly, that the jurors should take great caution and care in evaluating.
Right, I understand. I appreciate that. But you need to address their argument, which is it doesn't explain that one of the language isn't important, but the point is that accuracy is one of the reasons that we want these recorded.
Well, I think he did cover that.
Okay. Tell me about what he said that covers that.
Well, let me pull the language.
You don't have to be specific, but he actually addresses that, you know, we don't have a recording here of what was said, and you can take that into account.
Right. Our Supreme Judicial Court has expressed a preference that interrogations be recorded whenever practicable. An unrecorded statement does not present to the jury evidence of the totality of the circumstances, but instead only presents the jury with an abbreviated summary of those circumstances and the interrogating officer's recollection of the highlights of those circumstances. Consequently, when the Commonwealth introduces evidence of a defendant's statement that is the result of a custodial interrogation at a place of detention, and there is not at least an audio tape recording of the complete interrogation, the jury should use great caution when trying to assess the totality of the circumstances. You are advised that the absence of a recording permits but does not compel you, the jury, to conclude that the Commonwealth has failed to prove voluntariness beyond a reasonable doubt. I submit that covers it. Now, the defendant may have gotten unwarranted benefit by even having the instruction, because at that stage, for that first interview, he was not a suspect. He was a potential witness. One of the individuals who drove by the station in the half hour or so before contacted the police after he had heard about the murder and told them about the van that he had seen there. When he was telling that to the investigating officers, a dispatcher happened to overhear it and recognized the description of the van and summoned in the officer and said, "That's van belongs to my neighbor, Dennis Bateman." That's how the defendant was first contacted. Not necessarily as a suspect, but as a witness, a potential witness who was there. Now, they didn't know if he was there or if he had lent out his van to someone else. And so he was interviewed on the 18th of October. He was not a suspect. So this was not a custodial interrogation. So the defendant may have gotten an unwarranted benefit.
I hope that this doesn't take too much time to answer this question, so be as cogent as you possibly can. But right off the bat, the appellant talked about that this is an innocence case. And obviously, we're looking at these unpreserved errors through a substantial likelihood of miscarriage of justice, it's going to contemplate the Commonwealth's evidence. So can you give your 90-second best version of the compelling evidence?
Compelling
in your
evidence.
view?
Number one, the DNA on the actual murder weapon, the strap. There was 1 in 605 quadrillion randomly selected person. The DNA on the fingernails, as was mentioned before, 1 in 200,000. The defendant placing himself at the gas station that afternoon. The parade of witnesses who described someone either matching the defendant or his van. It's a very distinctive van, and one of the great coincidences in this case, the individual who sold the defendant the paint cans to paint the white van black, he was driving by at 6:30, immediately noticed the van and said, "That's what I expected from the lousy paint can job on the van." And that was, I submit an identification of the van. And that could be argued either way, as the other identifications could be argued either way. The defendant's attempts to cajole others into providing an alibi for the hours between 4 and 6 o'clock. He threatened Debrick Sweeney, saying that he would tell the police that he had sold him drugs. Charlene Jenkins, who he had seen later that night, he went back to her, and she felt threatened. He was very agitated. He tried to convince her that he was with her between those hours. The teller at the employee at the liquor store. There was a cab driver. It was a constant
Statements to his friends that he wanted them to take care of his wife, right?
That was 3 or 4 or 5 times he just said that in the immediate aftermath of the murder. He approached the victim's fiance the day after the murder at a different gas station.
Can I switch you to...
And said he had fingerprints. He was afraid fingerprints were on the purse.
Are you okay? Can I switch you? What is the great phrase, Justice Gray, snatching victory from the jaws of defeat or defeat from the jaws of victory? I can't remember the proper. There's a lot of mistakes made in a case. You're bringing in these 2 jailhouse witnesses, and you're not giving all the information, and then the detective makes a bunch of errors that aren't correct. How do we address that? Because you've done, there's a lot of mistakes made in a case that shouldn't have been this difficult to evaluate.
I don't think I conceded error in 5 areas. Where there were mistakes.
Even you've conceded. I mean, the Givens testimony has, I can't remember, they identify 5 errors. You've conceded error in 2 or 3 of them, right?
I conceded error on one where he was asked, for 2 phone calls, did Bogatz contact you?
Right.
It had already been established by both the prosecutor and the defense attorney through Bogatz himself that Bogatz had indeed contacted him.
That's the least serious. And nobody offered him a deal, and that somebody did offer him a deal, and that nobody else talked to him. We know 3 other people talked to him. There are a bunch of errors, right?
Well, the defendant's brief portrays a factual universe in the light most favorable to his argument.
Right.
Judge Agostini had a hearing, an evidentiary hearing, 2-day evidentiary hearing on whether Bogatz was a government informant or not.
I find you're correct on the law on that issue, so I'm not bothered by that. I'm more bothered by just how many errors are made and whether you had any duty to correct them at trial.
I see where you're...
The prosecutor, it's the part about where an answer comes up and the prosecutor doesn't do anything when the prosecutor's in a position to know that there's contrary information available.
Right, but these errors come up on cross-examination. Defense counsel has the information to impeach those.
That's true, because that's important, because the defense attorney can impeach by contradiction later. They don't have to take that extrinsic evidence that moment and prove the contrary of the denial, because it might not be as dramatic. So I'm not worried about those. But are there situations where the prosecutor knows there's contrary evidence and the defense attorney doesn't?
I think the one clear one is the one mentioned earlier, where Detective Lieutenant Gibbons said Bogads had not tried to contact him. There's a transcript of jail calls that he could. Now, Bogads had already testified, and both attorneys had established that Bogads had called him. So defense attorney knew that, and defense attorney, if he wanted to impeach the detective lieutenant further, could have pulled out those recordings. And then what does the prosecutor do on redirect? Well, can you explain why you didn't remember it? Well, there were 2 very brief phone calls. I had forgotten it was 2 years ago in the midst of a major homicide investigation. Judge Agostini made a finding that it was an oversight. It wasn't intentional. And in any event, it was already established. Everyone in the courtroom knew that Bogads had attempted to contact Detective Lieutenant Gibbons. Now, we have to step back and look at, so what's the defendant's argument here? That Bogads was somehow a government agent. There was an evidentiary hearing, 2-day evidentiary hearing, years later, but fortunately Judge Agostini was still on the bench, and he allowed evidence to be submitted where now United States Marshal Gibbons testified, the prosecutor testified, 2 state police lieutenants testified, and the defendant failed to establish that Bogads was a government agent. And failed badly. There was no evidence to support it, other than this, from 25 years ago, Bogads had told then Officer Gibbons
I agree
about
with
some house
you.
breaks.
I agree with you that he's not an agent. That's not, but their argument's broader than that. Their argument is that Gibbons is lying, and that if they, and that's important. Why don't you address that part of this too?
Right. So this was before Judge Agostini, and in his decision and motion for a new trial, he said there were some inconsistencies with Detective Lieutenant Gibbons's or Marshal Gibbons's recollections, but there was nothing deliberate about it. It was an oversight, not deliberate, and that was in there. Now, the defendant, there were some ambiguous interchanges during trial. The defendant says, well, this is referred to this. I counter, well, in the context actually referred to that. It's not clear. So
And
that's
how-
something that defense counsel can
How about the other
develop.
one, Sweeney? The argument is that Sweeney, and again, I understand he's not an agent, so I don't disagree with your legal analysis there, but they're also arguing that Sweeney has all kinds of incentive to lie that they're not able to pinpoint. You want to deal with that?
Well, Sweeney, it's unfortunate that Sweeney's paired with Bogads. Sweeney was a pretty minor player at trial. There was over 40 witnesses. His import was that the defendant had tried to get him to be an alibi between 4 and 6. There's no evidence that they were together on the day. There was evidence that sometime before the murder, the defendant had gone over Sweeney's house and Sweeney had sold him crack cocaine. Importantly, Sweeney does not go to the police. The police go to him. His name comes up in the investigation, and he says that indeed the defendant tried to get him to be an alibi. Defendant Sweeney pleads guilty the following fall. He's given 18 months sentence. In the run-up to trial, he's on probation. It's a dispute whether there was an active violation of probation or not. And he's given the prosecutor meets with Sweeney exactly one time, gives him the statement and says, is everything in there true before I put you on the stand? And he admitted, well, actually, I did sell cocaine to the defendant. He had denied it in his earlier statement from 2 years earlier. And so that's the basis of his cooperation agreement. They're not going to use that inculpatory statement against him. They're not going to charge him with a sale of cocaine to the defendant. So that's the basis of his deal. Now, if there were an open violation of probation, and
he's subject to a 10-year, he has exposure to going back to jail for 10 years, is that right? Or am I misremembering?
Well, when he pled guilty to these charges, which was a year and a half before he entered a cooperation agreement, the judge at the time said something that if he violates probation, he's looking at 10 years. And I have the quote in a footnote in my brief. That was a single remark in a plea hearing from a year and a half earlier. It's not transcribed until 4 years after trial. So the defendant is trying to make it as a discovery violation because we would not foresee that this person would later enter a cooperation agreement, and this somehow is exculpatory evidence that needs to be turned over.
Can you address the juror who made the comments about statistics and
Sure.
blackmails?
So it was asked earlier, what would have been a good follow-up question? So the question was, having that information, would that affect your ability in deciding the facts in this case? And the juror says, no, because it doesn't have anything to do with the specific case. And then there was a question, what would be a good follow-up? Well, there was a follow-up. Now, are you conscious of any feelings of racial bias or prejudice which might tend to influence your decisions in this case? And the answer is no. Now, this court's decision in Williams brought a lot of needed clarity to this area of the law. It parsed out the two different aspects. If a juror has a bias or worldview or opinion about the specific case, they may be asked to set it aside. If a juror has an opinion, a worldview, or a bias about something generally, there should be a follow-up question because jurors are allowed to have opinions and biases and worldviews, as this court in Williams said. And so there should be a follow-up question. Now, in Williams, this court did not mandate any particular phrase, and actually in footnote 8 of Williams, it says no special terms or particular phrasing is required. Now, Chief Justice Gantz, in a concurrence, put himself sort of in that case in the trial judge's role. He said, I've questioned thousands of jurors in my 11 years as a Superior Court judge, and I like to think that if this had occurred, that I would ask a particular question. And the particular question he thinks he would have liked to have asked is there anything about the subject matter or your views about the subject matter that would affect your ability to be fair and impartial in this case? As the follow-up question, Judge Agostini actually used the actual language as his follow-up question. So
How many
after the juror talked
peremptories?
about statistics, I'm sorry?
How many peremptories were left at that point?
Ultimately, each side retained 4 peremptories.
So after this would have been, we don't even know, was this in the beginning? I can't remember. This juror was 22.
This was on day 2 of jury selection.
So the defense counsel had a lot of peremptories at this point.
Right. And so, yes, the whole issue is waived, first of all. And so if anything...
Still considered substantial likelihood.
Substantial likelihood. Now, the defendant in his principal brief says, structural error. In the reply brief, the defense says, acknowledging it should be, the defense says substantial risk, but should be substantial likelihood. Now, at oral argument, the defendant is going back to structural error. It's a substantial likelihood. The burden's on the defendant, and the burden can't sustain, and the defendant can't sustain that that burden. If there were error, I submit under Williams, Judge Agostini handled this properly because his follow-up question was having that information, this is after the juror mentioned statistics, having that information, would that affect your ability in deciding the facts in this case? That's almost word for word what Chief Justice Gantz in his concurrence in Williams hoped that he would have said if he were in the position. Now, there is no mandated verbiage to be used under Williams, but that was a pretty good one, probably 10 or 12 years before Williams. And again, there's probably no area of the law in which a trial judge is accorded more deference than in juror selection. The trial judge sees the juror, can decide.
I'm not sure that's the case anymore. But yeah.
Well, I think Williams really trusted, I guess is the word, trusted trial judges to do their job and specified that, if a juror has a worldview, they need not put it aside unless it's about that particular case. If it's some sort of view, they're entitled to have it because we want a diverse jury, and everyone brings their views into the deliberation room. What you don't want is it to affect their ability to judge the facts of the case, and the law is prescribed by the judge in the instructions. Judge Agostini did that. Now, the defense counsel was a very experienced attorney. He was content with this juror. The prosecutor was a very experienced prosecutor. She was content with this juror, and Judge Agostini, who was an experienced judge even back then, and he found the juror 17 years ago.
It's a long time ago, right.
And he found the jury to be indifferent. And this is only an issue. The defendant has filed multiple motions for a new trial. He is on his 6th appellate attorney. It's only an issue now in the brief before this court.
Can you address, before we lose you, there's this doctoring of the tape issue. That's in a pending motion for a second new trial, is that?
There's a pending motion for a new trial. Judge Agostini, there's a status hearing on January 4th, I believe.
What is the argument in there?
The argument is that the police doctored the second interview, doctored the second interview to make the defendant look bad. It's not clear what they took out, what, pearls of exculpation were removed from
the basis of this is what? And what do we have of that in this record?
Well, the defendant included the issue in the brief.
Yet. It hasn't been decided, right?
No. And each side has an expert, and this will be, hashed out before Judge Agostini. But that's the basis of it. Is the police were trying to make the defendant look bad and took out unspecified statements to make him look bad.
The Commonwealth's experts in that case are admitting that the tape has been altered, or they're
no. We're still in consultation with the expert, but we expect the report to say that there was absolutely no tampering of the tape. This is in the wake of DJ and Batista. Officers were given these handheld Samsung recorders, and they're trying to figure out how to work them.
Okay.
Unless the court has any further questions, I'll rest on my brief.